Good afternoon. We're going to get started. If I could have your attention, please. You're in the Insurance Committee's Subcommittee, Life and Health. And if we could, we'll open, if you would, lead us in prayer. Thank you, Lee.
Please bow your heads. God, bring us to this day to make the best decisions for those in Georgia. Put your hands on us and help us do what's right and to protect all the others, and bless this group in this proceeding today. Amen.
Thank you. I'm going to go ahead and explain. We have 4 bills today, and we have this room for 1 hour. We have a lot of folks that want to speak to this bill, to several of the bills, actually. I want to make sure that everybody is brief and concise so everyone can be heard. And we are going to start with House Bill 80. Senator Kirkpatrick, if you'd come up to the podium, please.
Thank you, Madam Chair. I'm bringing you all Senate Bill 80, and the LC I believe that we're working on now is 460475S. And when I picked up the copies, the paper was still warm, so that gives you some idea how many changes this bill has been through. I think this is revision number 17 of the original bill, but before and after it passed the Senate. And the reason for that is because I've been meeting with stakeholders affected by this bill for several months. I appreciate all the feedback, and I've incorporated many of the suggestions into this version of this consumer protection bill, both before and after Senate passage 50-0. Special thanks to the Department of Community Health and the Office of the Commissioner of Insurance for help with the bill, as well as representatives from the insurance industry and many advocacy groups, including the Medical Association. The attorneys from Legislative Council, Senate Research, and the LG's office have done a lot of work on this as well. Many of you know that I practiced orthopedic hand surgery for over 30 years, and I have a lot of experience with the prior authorization process for getting approval for medical treatments, tests, surgery, and drugs. Over the years, the process has become more time-consuming and difficult for healthcare providers, and much staff time is spent dealing with this process that could be used providing patient care. I imagine any of you who have needed medical treatment are very familiar with this issue. This consumer protection bill does not argue whether prior authorization is good or bad, saves anyone time, or helps or hinders patient care. It simply attempts to add transparency to the process and clarify the rules of the game for all the parties. I've been asked to keep this short, so I'm not going to go line by line through the bill, but the bill amends Title 46, the law that's already in place for healthcare utilization review managed by the Insurance Commissioner. Article 1, which is going to be about the first 16 pages of this long bill, are primarily existing law and definitions. There are a few new definitions in there, but the meat of the new bill starts on page 16 with Article 2. And I'll just sort of hit the highlights of what this bill does. It makes requirements for prior authorization available to providers on insurance company websites, and also the clinical criteria at the time of an adverse determination, and also calls for updates to be added to the website. It asks for aggregated statistics to be available by carrier and by plan on approvals and denials, and a couple of other criteria. And then it calls for peer-to-peer communication with a qualified healthcare provider prior to an appeal. It defines the qualifications and definition of a clinical peer, and it also states that prior authorization is good for 45 days after approval, provided the service is provided during that period of time, except for Schedule II drugs. It establishes a timeline for prior authorization for elective procedures of 15 days after all the information has been submitted, and for urgent procedures, 72 hours. It also provides for any incidental findings that might turn up during surgery. And then it also, if a patient changes, if an insurance company changes the utilization review entity, or the patient changes plans within a company, it also honors the PA for 30 days, but not if you change insurance companies. And then it also provides for a procedure for violations that might happen, and it codifies the role that DCH plays in the whole process. And with that, I'll stop and be happy to answer any questions.
Do we have any questions from members of the committee? I see none. And I know we have several people that would like to speak to the bill. So if those in the audience that would like to speak to the bill, we have a list. Let's see. On Zoom, we have Dr. Lichtenfeld.
Thank you, Madam Chair. I'm Dr. Len Lichtenfeld, formerly Deputy Chief Medical Officer of the American College of Physicians. And I've taken the liberty of having my wife, Dr. Sandra Reed, join us for this testimony. And I'm honored to speak on behalf of Senate Bill 80 and Dr. Kirkpatrick's work, along with those of her colleagues. The American College of Physicians, Georgia chapter, represents $3,600 in support of this legislation. Doctors, I'm sorry. Prior authorizations are not new, and we've been going through them for decades. It's clearly something that we've had to live with. What's changing is that there's a substantial increase in the volume of these requests, and they're moving further downstream into the medical system. I asked Sandra to join us today because she's experienced this personally. The types of authorizations that she's been asked to do are getting down to generic birth control pills, for example. So it's become a huge burden. Doctors are aware of that. We need to be able to get back to caring for our patients, to do what we do best, no matter whether it's internal medicine, GYN, family practice, whatever. There's a role for prior authorization, but we need clear, concise rules of the road so everyone knows what to expect during the course of their practice. It has become a real intrusion. So we appreciate the efforts of Dr. Kirkpatrick, as I mentioned, as well as the legislature, to try to address this issue and make it equitable. And if I may, just briefly ask Sandra if she has anything she wishes to add.
Not really. It's just that it seems like it has happened within the last 6 months that these prior authorizations are becoming more cumbersome in the practice. It's requiring more and more time of our staff for medications that normally would be covered under a generic, like birth control pills and other generic hormonal replacement drugs. My staff is now spending more and more time. The formularies are changing. We don't know what is covered. There's no transparency. And most of the time we would adapt to the formularies if we knew what they were, but we don't. And we're taking patients who've been on long-term pills and having to change that. And we're not talking about expensive medications here. It's a nuisance to the patient. It is a nuisance to our practice. It takes time and hinders us from adequate patient care.
So thank you, Madam Chair, for your time, your attention to the committee. We appreciate your support and look forward to having this legislation passed into law. Thank you.
Thank you very much. Does anyone have a question? Thank you very much. We have next on the list is Heather Breeden.
Good afternoon, Chairwoman Taylor. My name is Heather Breeden, and I represent the National Multiple Sclerosis Society in Georgia. On behalf of the nearly 1 million individuals who live with multiple sclerosis in the United States, the National MS Society wishes to offer support for SB 80. MS is an unpredictable, often disabling disease of the central nervous system. It is the leading cause of disability in young adults. For people with MS, prolonging ineffective treatment and delaying access to the right treatment may result in increased disease activity, loss of function, possible irreversible progression of disability. For example, a person with MS may have to delay receiving an MRI or accessing prescribed medication for weeks or even months until their insurer's prior authorization forms are submitted, reviewed, and approved. People living with MS may increase their risk of lapses in treatment or even worsening the course of their disease as a result of these delays. Specifically, as our position relates to SB 80, we support the timelines for turning around both urgent and non-urgent requests, requirements for the keeping and reporting of statistics, the clear delineation of who is a professionally appropriate person to conduct the review, and the creation of a standardized, accessible process. We encourage the committee to continue working with Senator Kirkpatrick on this bill and pass it out of committee as soon as possible. We are grateful for her desire to improve the health outcomes of all Georgians. Before closing, I wish to draw your attention to an attachment to my testimony by a consumer from Flowery Branch, Georgia, with MS. She shares her firsthand experience with prior authorizations, which led to delays in her treatment and long-term consequences following her MS diagnosis. We wish to thank the Insurance Committee for this opportunity to offer testimony, and I'm happy to answer questions.
Thank you very much. Does anyone have any questions for our speaker? I see none. Thank you very much for your testimony. All right. Next on the calendar will be Jeff Breedlove, and I believe he's in person. If you would come to the podium. Could we get you to speak a little closer to the mic? That's better, thank you.
Now?
That's better.
There you go. It
Thank
wasn't
you.
on. So I'll just start over. I'm Jeff Breedlove, and I'm a person in long-term recovery from substance use disorder, and I'm here on behalf of the Georgia Council on Substance Abuse, mainly to thank Senator Kirkpatrick for her leadership on this important bill and to say that many tens of thousands of people are aware of this bill across Georgia in the substance use disorder recovery community, and we support it. I do want to say that we were happy with the original bill, and we acknowledged the process, and as she acknowledged, there were several versions of it that went on before passage in the Senate. We support, at a minimum, the version that passed the Senate. That's our hope. That's a bill that provides true transparency for consumers, for the taxpayers, for the families of Georgia. We appreciate whatever work is done to move this bill forward, but we must be transparent when we say some folks have worked very hard to water this bill down. And the people that are being pushed aside because of those changes are, in fact, the people of Georgia, the families of Georgia who don't have time for this kind of stuff here. They're working during COVID in a pandemic to keep the store open, to keep the family afloat, to pay the bills, and they don't have 2 or 3 hours every time, as we know happens. What they need is a level playing field. And what I will end on is saying this. Again, thank you to Senator Kirkpatrick and to the committee for moving the bill forward, we hope and we ask. But at the end of the day, when decisions have to be made between the insurance community and the consumers and families of Georgia, we do ask with respect that the General Assembly side with the people of Georgia. We need a true bill that's transparent. Thank you.
Thank you. Does anyone have a question for the gentleman? Okay, thank you very much. Next we have on Zoom, is it Todd Sintrin?
Yes, Madam Chair, thank you.
Thank you.
I am representing NAMI Georgia today, the National Alliance on Mental Illness, the Georgia chapter. We are a behavioral health care advocacy organization. Calling today to express our support for Senate Bill 80. It is important that transparency in the prior authorization process is present. This is a very important issue in ensuring that mental health parity in the state of Georgia is present. I want to thank the committee members for taking this bill up and hopefully passing it through. Thank you, Senator Kirkpatrick, for your leadership, and I'm available for any questions.
Are there any questions? We see none, thank you. Next we have Shannon Lake. I believe she's on Zoom.
Hi.
Thank you.
Good afternoon, Chairman Taylor. Thank you for letting me speak today. I'm here today both personally as a patient and in my capacity as the Georgia Advocacy Chair for the Arthritis Foundation. I'm one of the millions of Americans with inflammatory arthritis. This means my immune system attacks my joints and my organs. It causes pain, swelling, and stiffness in my joints, as well as overwhelming fatigue. This is a progressive, destructive, debilitating disease. Arthritis is the leading cause of disability in the United States, with 54 million of us with doctor-diagnosed arthritis, with there are 100 different types of arthritis. During the pandemic, we all became a little more aware of treatments that can effectively target the immune system. One major type is the monoclonal antibody. These are specialty drugs that block specific cytokines or inflammatory chemicals in my body. Some background, I have had this disease since I was 10 years old, for 36 years. I've been to many rheumatologists and tried many treatments. I'm about to start my 13th biologic in 23 years. Sadly, only 2 of these 13 miracle drugs have helped me. More than one has been crossed off the list due to side effects like anaphylaxis. One of the challenges that we have is that monoclonal antibodies, you can create antibodies to them at any time, rendering them ineffective. This risk is exacerbated by starting and stopping your treatment. Prior authorization has a place here. I have run into many problems over many, many years. Starting a new treatment, I've had my disease progress while I've been waiting for new authorization, even while waiting for authorization for proper imaging and testing. And then most recently, I found a drug that worked, and I was able to work for 2 years until 2017, when I had to change insurance, and my new company no longer would cover that, the infusion form. We went through the whole process, and in essence, I still, 4 years later, or 3.5 years later, still don't have access to my medication because of the challenge with formularies and prior authorizations. And I've been unable to work since then. Thank you so much for your time.
Does anyone have a question for the lady? Thank you for your testimony. We appreciate it. Next, we have Roland Beam. If you would go to the podium.
Good afternoon, Madam Chair and members of the Life and Health Subcommittee. My name is Roland Beam, and I serve on the Board of Directors of the Georgia chapter of the American Foundation for Suicide Prevention. Our mission is to save lives and bring hope to those affected by suicide. Using a fast food metaphor, when I signed up to testify last week, I thought we would be discussing the Big Mac of SB 50, the one passed 50-0 by the Senate. Instead, with the changes made to the draft bill we are discussing today, we're left with only a couple of the sesame seed buns. There's no beef, no lettuce, no cheese, no pickles, no onions, and certainly no special sauce. The buns bill leaves Georgia voters with the illusion of transparency and accountability in prior authorization processes. One of the most insidious ways insurers use the demented prior authorization process to fatten their bottom lines at the expense of Georgia voters is in the ridiculously limited time periods for which prior authorizations are granted. Authorizations are frequently limited to a period of 1 to 3 days before requiring another prior authorization request. The process inflicts trauma on trauma. Georgia voters already struggling with their child being diagnosed with a chronic and recurrent illness are forced, hat in hand, to beg for the equivalent of table scraps, even though they paid for the whole menu. The Big Mac requires prior authorizations to be valid for 6 months. The Buns bill eliminates the 6-month requirement and replaces it with nothing. The Big Mac requires insurers to decide on a prior authorization within 72 hours. The Buns bill requires a decision within 15 days after obtaining all necessary information. What constitutes all necessary information is not defined, leaving it up to the discretion of the insurers. Consequently, under the Buns bill, the insurers could string out prior authorization for weeks and months. Like justice, healthcare delayed is healthcare denied. the consequences of delayed or denied health care due to the prior authorization process. Voters die, families are shattered, and communities bereaved. Please revert to SB 50 as passed 50-0 by the Senate and join with AFSP Georgia in saving lives and bringing hope. Thank you.
Does anyone have a question for the gentleman? Thank you for your testimony. Next, we have Dr. Ben Hunter.
Madam Chair and Senator Kirkpatrick, thank you again for your advocacy for providers and patients. I'm grateful for the opportunity to discuss this bill today. I'm a physician, a psychiatrist. I am the medical director at Skyline Trail, a residential psychiatric facility in Brookhaven. I'm also a Board of Trustees member of the Georgia Psychiatric Physicians Association, and in line to become the president of that organization in a few years. So if you ask me or any of my colleagues, this is one of the most important issues we're facing as healthcare providers. It is one of the most frustrating and obstructive issues on the table in terms of healthcare and the care we try to deliver to patients. It's not just because of the inefficiency and the time it wastes from provider schedules and the inability to do more important things like see patients and provide care. It's also because we know this directly impacts patient outcomes in a negative way. This process, the prior authorization process, is opaque, it's unpredictable, it's openly biased towards cost savings for insurers over outcomes for patients and choosing the correct care. And this is a game. If we're being honest, this is a game that we've all signed up to play. And all we're really asking for in this bill is the opportunity to have a set of rules to play by that we can all understand and that patients can understand what they've bought into and what they can expect. So when we discuss prior authorizations, as physicians or as healthcare providers, we enter into a conversation typically with people who have a limited understanding of the patient and care situation at hand, with a lower level of qualification in terms of understanding of the medical knowledge, and with really no plausible understanding of the consequences of the decisions they're making and supporting or denying in their dealings with this prior authorization. Again, this turns into a conversation where we know our role as a provider is to try and bulletproof our argument so that none of the sort of inane reasons that these can be denied is accessible to the reviewer. And we're okay with that. Again, we just want a standard set of rules to play by. The unfortunate thing is that patients and doctors at this point understand that the medical opinions of the care providers, the experts, and the people who are advocating for the patients on a daily basis carry little to no weight in this process. Again, in many cases, the treatments proposed as alternatives or on-formulary alternatives for medications or alternate levels of care for a field like psychiatry are not equivalents at all. They're completely different agents. They're completely different treatments with no medical knowledge to back the equivalency of these things. For example, in psychiatry, this often comes down to being forced to choose medications with clearly different side effect profiles. Weight gain, metabolic syndrome, long-term health consequences like heart disease and stroke and heart attack, versus medications that are more effective and less side effect prone and roughly, again, equivalent in the sense that they're only in name are they equivalent. They're in the same class, but clearly not equivalent. So in any case, I think the result here is we've gotten into a situation where providers and patients see insurance companies as obstructive and not as their allies, but actually as, again, adversaries in this goal of reaching long-term wellness. I think we can find a resolution here where, by choosing the right treatments, by following provider recommendations early on in the process, you ultimately reduce costs down the line by taking care of issues early and preventing the long-term issues that follow when you don't take care of them early. So all we're really asking for, again, is the opportunity to do medicine the way that we've been taught to do medicine, the way that is prescribed by the treatment guidelines that are proposed by our professional organizations, and to be able to essentially provide the care that we're all trained to do through our expertise and experience. And at the end of the day, again, I think this ends up costing insurance companies less, it gets patients better outcomes, and it allows for a system where we're all working together for the sake of patients. So again, very much appreciate your time, and I'm happy to take any questions.
Thank you. Are there any questions for the doctor? Thank you very much for your testimony. Now we have Mary Daniels. Is she on Zoom? Okay, let's go to Laura Colbert.
Hello, good afternoon, Chairwoman Taylor. It's really nice to be here with you and with the rest of the committee this afternoon. I'm Laura Colbert. I'm with Georgians for a Healthy Future. We are a consumer advocacy and policy group. We support SB 80 for many of the same reasons that our partner and peer organizations have outlined, so I won't go back through that. But what I will reinforce is that we are especially supportive of the version of SB 80 that was passed by the Senate, and we hope that the committee will consider restoring some of the provisions that were written into that version. We would especially ask the committee to consider the previous more extensive reporting metrics that insurers would be responsible for publishing publicly, a specific time frame under which prior authorization determination remains valid for chronic and long-term conditions. We'd love to see that at 6 months, if not longer, and the stronger enforcement mechanism that was in the version of SB 80 that was passed by the Senate. We are very grateful for Senator Kirkpatrick's work on this bill. It certainly moves us in the right direction by increasing transparency and standardizing prior authorization to a certain extent, but we know consumers need just a little bit more, so we hope the committee will consider that. Thank you so much for your time this afternoon, and we look forward to working with all of you on this issue.
Thank you. Are there any questions for the lady? Thank you very much. Is there anyone here that wants to speak to the bill that has not signed up? Please come forward and identify yourself, please.
Good afternoon, Chairman Taylor, members of the subcommittee. My name is Scott LaFranco. I'm here on behalf of the Georgia Dental Association, represent over 3,500 licensed dentists in the state of Georgia. I haven't had an opportunity to see the sub that's before you, so I hope you don't mind if I could ask a question or maybe ask for a point of clarification. We do fully support the version of the bill that passed out of the Senate. There was a concern about some of the teeth of the bill, as some of my predecessors have testified to, especially with regard to whether a prior authorization is a guarantee of payment. Has that made it into the sub?
Do you want to address it or you want me to address it? It is not in there because a pre-authorization is not a guarantee of payment. There are things when you look at the adjudication of the claim that can change from the time the pre-cert was done, even if an employee is still employed or if they have changed plans. There's a number of events that can happen, and so that was removed from the bill.
Yes, ma'am. Okay. Well, there was language in the previous version of the bill that did say that it would be a guarantee of payment unless there was an instance of loss of coverage, fraud, factual misrepresentation. So there was some attempt to tighten those concerns, and I think that's a fair way to address some of these concerns with maybe the treatment changing in the midst of the course of the procedure. And again, on behalf of the GDA, I'd respectfully ask that you all reconsider that particular point, because it does give this piece of legislation some teeth. And it was also, in my opinion, drafted in such a way to offset some of these concerns. And thank you for recognizing me, and I'll be happy to answer any questions if the subcommittee has any.
Are there any questions for the gentleman? Thank you. We appreciate it.
Thank you, Madam Chair.
Yes, please come forward and identify yourself.
I'm Bethany Scher with the Medical Association of Georgia. We represent more than 8,000 physicians across the state in all different specialties. We would also like to thank Senator Kirkpatrick for her work on this. I know it has not been an easy process. Thank you, Chairman Taylor, for hearing this bill. Prior authorization has come up time and time again when we talk to our physicians about the issues that they're facing in their practices and what impacts the way that they provide care to their patients. And I will say that one of the biggest problems is that we have seen physician practices time and time again tell us that they are having to hire additional staff to only do prior authorizations. So they're having to hire an additional staff member that is increasing the costs of them providing the care, and most prior authorizations are eventually approved. So it's it's an additional salaried person that is there to only do prior authorizations for, I've seen statistics as high as 95% of prior authorizations are eventually granted. So this is a large issue for many of our physicians. We would prefer the version that came out of the Senate. That bill protected patients with chronic conditions, and one of the reasons that I'll sort of point to that provision is that now that we've extended the timeline, if you make somebody go through a prior authorization every month for the entirety of their care, and it takes 15 days to get a response to that prior authorization, there are delays that are inevitably going to happen from doing that. And it's just a very difficult process to get through. There is a lot of back and forth phone calls. There is somebody that basically needs to babysit the prior authorization through the process, and it just can really increase the time that it takes a patient to get their care. And 15 days is a long time if you need that treatment. So we appreciate this committee's work on this and appreciate Senator Kirkpatrick's work on this, and we ask you to support fixing many of the issues with prior authorization that SB 80 still fixes, but we would like to see it fix even more things if possible.
Thank you. Are there any questions for the lady? Thank you very much. Please come forward.
Thank you, Madam Chair. My name is Rick Ward. I'm with the Georgia chapter of the American Academy of Pediatrics. This is an issue in pediatrics as well. The chapter represents over 1,800 general pediatricians and pediatric subspecialists around the state. You have in your packet a letter of support for SB 80. We know that this is an important step forward, and we think it's a reasonable bill, and we look forward to having the process go forward and finally getting some reasonableness in the standards. I will read a couple of sentences out of the letter. We write today to express our strong support for this important bill. Our view is based on thousands of encounters by our member physicians in caring for children. SB 80 will be a welcome step in providing some standards and reasonable requirements around prior authorization as utilized by health insurance companies. Unfortunately, pediatricians often encounter prior authorization policies of insurers that are inappropriate, unreasonable, or so opaque that they serve to delay or deny care for the child. We appreciate your consideration of this bill, and we urge your support of it, and we'll follow the process to the end. Thank you.
Thank you very much. Are there any questions for the gentleman? Thank you. Is there anyone else to speak? Please come forward to the microphone.
Yes, thank you, Madam Chair, members of the subcommittee. My name is Jesse Wethington. I'm the President and CEO of the Georgia Association of Health Plans. We are with you today to express mainly our gratitude for Senator Kirkpatrick. As she stated, she has worked extensively with us on multiple revisions of this bill. The substitute that you have in front of you, the insurance industry is neutral on this bill. We think the substitute is a good compromise that takes into account both the interests of patients, providers, and the insurance community as well, while providing some of the benefits that the Senator outlined. I won't read from my prepared remarks in the interest of time, but I just wanted to appreciate our gratitude to the Senator for working with us, various other stakeholder groups we've been in communication with, and to the chair for entertaining the bill.
Thank you. Are there questions for the gentleman? Yes. Go right ahead.
Thank you, Madam Chair. Thank you for your testimony. My question is regarding, I'm not that familiar with the original bill that came out, but the 15 days, can you help us understand why it would move from a much shorter period of time to over 2 weeks?
So the substitute version of the bill, broadly speaking, this will treat licensure of this function much like hospitals are licensed by having us have a national accreditation procedure. Those national accreditation standards, so there's groups called National Quality Assurance Association, URAC, that we would be accredited for this purpose. They have standards of 72 hours for an urgent turnaround time, so that is in this bill, 15 days for a non-urgent turnaround time for a PA decision.
Given the efficiencies of the way businesses operate now, don't you think that's a little bit, I know nobody waits 2 weeks for a paycheck, or if you're a new hire, you can get the information in the system. Don't you think that's a little bit long, given the systems and platforms that modern American businesses operate on now?
Well, yes, sir, that's a great question. In fact, we're able to do many of these in a matter of minutes. We really push providers to get onto our electronic prior authorization platforms that make these processes highly automated or happen in a matter of minutes or seconds. Or there's another practice that the industry is adapting to try to deal with some of this administrative overhead called gold carding, a practice where if you will agree to meet certain evidence-based clinical practice standards, we will not subject your practice to a PA at all at that point. So there are ways we're trying to get around this, to your question.
Well, would there be ways that we can fix this in code moving forward? Is this bill, I'm hopeful that it'll go to a conference committee. Would the industry be open-minded to maybe tightening up that window a little bit? Maybe just have some special carve-out exceptions of why it would go 15 days?
So for in an emergent situation, there's no prior authorization today. In an urgent situation, which is defined in this bill, it would be 72 hours. And then for non-urgent routine, 15 days. And those are the national standards. We feel like those are sufficient for the purposes of this bill.
Thank you.
Thank you. Are there any other questions? Thank you. Does anyone else need to speak or would like to speak? Yes, please go forward and identify yourself.
Madam Chair, thank you for the opportunity. I'll be brief. My name is Michael Power. I'm with the Pharmaceutical Care Management Association. We're here today neutral to the substitute language that's provided by Senator Kirkpatrick. And we do like to thank Senator Kirkpatrick for her work on this important issue. I think we've heard a lot of testimony how important prior auth is and how we get this right. I will say from our perspective, with what we believe is in the substitute language today, Georgia will lead in prior auth. This will be one of the more stringent prior auth pieces of legislation in the country. And so we think it's a good first step. And we thank you all for this thoughtful time and thoughtfulness in this process. Thank you.
Thank you very much. Any questions? Okay, we've had a lot of discussion about this bill. At this time, the chair will entertain a motion.
With a hope that it'll hit a conference committee and get a little bit more improvement. Move to pass.
We move in a second. All those in favor say aye. Aye. Any opposed? Your bill passes. Full committee tomorrow. Excuse me.
Check online.
Yeah, let's check online. Were there any?
Aye.
Okay.
Aye.
It's passed. Okay, full committee. Thank you. Okay, now we'll move on to House Bill 82, if you'll come forward. Dr. Al?
Oh, everyone's leaving just for the best part. I don't get it. What's going on? Good afternoon, everyone. For those that I don't know, I'm Michelle Au. I represent the 48th District on the Senate side, and when I'm not here, I'm an attending physician at Emory St. Joseph's Hospital. So thank you, Madam Chair, and thank you to my colleagues for allowing me to present SB 82, which is a patient protection bill, which seeks to clarify insurance coverage of emergency medical care. And my team should be handing out some packets that we can follow along with. So this is a bipartisan bill. It's a very straightforward bill that closes a harmful loophole. I know some of you heard the hearing on this, so I'm just going to hit the highlights. But with your favorable consideration today, I would really hope to help a lot of patients. And this bill passed 50-1 in the Senate with a strong bipartisan team helping to get it through. So I especially appreciate the excellent suggestions I've received from my colleagues, both on this committee, Chairwoman Taylor in particularly, and in the House, and we'll walk through some of those changes in just a little bit. So I think we've really worked together to make this bill better, and I think we're going to help a lot of patients. So just to recap from last time, and some of you are already here, the problem we're aiming to solve with this bill is the phenomenon of insurance companies denying claims for emergency medical care when they, the insurance companies, decide after the fact that the patient's presenting symptoms or concerns didn't qualify as emergencies. And again, the claims that we're aiming to cover with this bill are not ER visits that are made for trivial reasons. Okay, we're talking about cases of patients brought in with crushing chest pain. We're talking about cases of patients brought in with broken bones after car accidents or after domestic abuse, assaults requiring law enforcement intervention, patients with gunshot wounds, and patients in critical sickle cell crisis necessitating hospitalization. These are examples of real claims denied by insurance companies that reviewed patient records afterwards and determined that these reasons did not meet the correct threshold for emergency care. So this bill is based on a legal precedent known as the, quote, prudent layperson standard. Now, what does that mean? The prudent layperson standard requires insurers to cover services where, and this is the language, a rational person without professional or specialized knowledge in medicine would believe that their condition would be one of many emergency medical conditions. For example, heart attack, stroke, severe injury threatening bodily function, etc. And this bill simply points out the obvious, that we don't always know what a patient's condition is or will be when they present to the emergency room. But if they meet this prudent layperson standard for seeking emergency care, then this care should be covered by the health insurance policies that they have for this very reason. I have some experts here today ready to give testimony on this bill, and I don't want to take away any time from them. So I'm just going to very briefly walk you through this information packet that I've given you to look through in consideration of this bill. Okay, so you should have this packet here. It has some tabs on it, so let's just walk through it really quickly. First tab, pink tab, is a copy of the House Study Committee that was commissioned in 2018 to study this exact problem. So thank you to the House for commissioning this study, which yielded some very important information. I won't make you read through the whole thing. It's a lot of pages, but I'll just cut to the chase that the results of this House study showed, quote, Georgia legislators should consider responses to harmful ER policies and the challenges outlined in this report to prevent patients from unfairly carrying the cost of emergency medical services, unquote. So thank you. This was a very good report and taught me a lot. Second piece in your packet, purple tab. This is written testimony from Dr. Chip Pettigrew, who is going to be here to testify via Zoom today, and he is the former president of the American College of Emergency Physicians, testifying in favor of SB 82. Third tab, yellow tab, is testimony written, this was presented in the Senate committee, from Dorothy Leon Glazer, who's the executive director of Advocates for Responsible Care. And the page after her written testimony shows the 41 patient advocacy groups that she represents. And she is speaking out strongly in favor of our bill, and you will hear her testimony in just a bit via Zoom. Fourth tab, the blue, has two lay press articles that detail the scope of this issue and tells real patient stories. One is from Vox, which is a national online news outlet, and the second one is from the AJC. You may have seen this article in 2019. It has a very memorable photo on the front, and you can look at those at your leisure. And the final piece in your packet is the first 3 pages of a federal lawsuit in which Blue Cross Blue Shield is being sued by the American College of Emergency Physicians on behalf of its members and the Medical Association of Georgia for this very issue of retroactive ER claim denials. So, I also want to briefly walk you through the changes we've made to this bill based on your excellent and very well-considered recommendations from our last committee hearing. And again, I thank Chairwoman Taylor for her input. So today we are working through LC 460468S. So hopefully everyone has the most recent, this is the 5th substitution to this bill. So, a couple of things that we did change, and thank you so much for the suggestions. In lines 25 through 27, we added some language that is specific. This one carves out plans that are ERISA plans, Employee Retirement Income Security Act plans, which is Chairwoman Taylor suggested, so that was a very good suggestion. Thank you so much. Other things we changed in lines 83 through 84. I'm going to lump these together because they're the same change. Line 85 and, line 27, we added under the list of healthcare providers, which is a long list of types of providers, we added emergency medical technician, which thank you for that suggestion as well. That's what we tinkered with. And with that, I would like to invite some of our expert testimony to come and testify on behalf of this bill. But just in closing, there are 2 harms that we are aiming to avoid with this bill. The first harm we are trying to avoid is patients being, as we spoke about, unfairly burdened with the debilitating cost of their emergency health care. The second harm we aim to avoid is patients hesitating from seeking out needed urgent or emergent care because they are worried about possibly having to shoulder these costs if the insurance company tells them that they didn't have a good enough reason for coming in. And so with that, I ask for your favorable consideration of SB 82. Together, I hope we can help a lot of people, and I am happy to take any questions that you may have at this time.
Do we have any questions for the lady? I see none, but we do have a couple of people that would like to speak to the bill. If you would go to the podium, please. Dr. Chip Pettigrew.
I think he's on Zoom.
Okay, thank you. Yes.
Good afternoon, Madam Chair and committee members. I'm Chip Pettigrew. I'm with the Georgia College of Emergency Physicians. Thank you for letting me speak on behalf of SB 82. In 1996, the Georgia legislature adopted the federal prudent layperson standard as the standard for the prudent layperson in Georgia. So it mirrors exactly the federal language. However, since then, Georgia's insurers are denying or reducing payments for patients seen in our hospital emergency departments. They're using proprietary lists of final or interim or working diagnoses to downcode or deny payment for these emergency services. This is being done every day in Georgia. I talked with a colleague last week, and he has 9,000 cases that have been denied or downcoded by one single insurer. These actions clearly violate both state and federal laws regarding emergency medical care and the PLP standard. These actions are also a powerful disincentive for Georgia's citizens when considering going to the hospital emergency department when a possibly dangerous condition exists. We need our legislature to step in and clarify that an emergency medical condition is determined by the prudent lay person based on their interpretation of their own symptoms as per state and federal law, and not based at some later point in time upon a diagnosis upon review by an insurance company representative. CMS has been consistently clear in this issue. In my testimony, I've added a citation from there that says that coverage and payment must be made taking into account the patient's presenting symptoms rather than the final diagnosis. I think it's time for the legislature to step up and make crystal clear in state law that the prudent layperson is regardless of any diagnoses, final, interim, working, or any other diagnoses. Thank you for your time. I'm available for questions.
Thank you. Is there anyone that has a question for the gentleman? Thank you. There are no questions. Next on Zoom, we have Dorothy Leon Glaser.
Thank you very much, Madam Chair. I appreciate coming before you again, as I have many times on this committee. We are here in support of this bill because it directly affects patient care. I am the executive director of the Advocates for Responsible Care. We also lead the RX and REACH Coalition. As Dr. Au already showed you, we are 41 members, from medical professionals to patient care advocates. This bill is very important to us. I am a 40+ year nurse specialist in taking care of patients. And one thing that we know for sure is that in doing this work, we have to be ready to be able to answer to any warning signals that a patient might be in jeopardy. We cannot lay this burden on the patient to be able to decide if this is a situation where they will be able to receive their coverage or not be denied an insurance claim based upon their symptoms. We had a patient recently who has kidney failure, and they were doing well and progressing well, going to work, supporting their family, and started to have very dire symptoms at work and hesitated to go to the hospital. Finally, the family called me, and it was at least almost 24 hours later. And I insisted that they go to the emergency room. They waited too long. This gentleman went to the emergency room. He was falling in and out of consciousness. He has not regained consciousness yet. He had a major stroke. His hesitancy and the family's hesitancy in him going to get emergency care was that he was afraid that his claim would be denied and that the financial burden would be left onto him. Our healthcare system burdens the patients too much without giving enough back. So I urge you to pass this bill, SB 82, today, because we need to be able to lift that burden from the patients. We need to have doctors be able to treat the patients without worrying that they will not be allowed to have coverage for their claims, and that the doctors are free to make the medical decisions that they need to make, as well as the rest of us who are medical professionals and who live our lives trying to save the lives of others in Georgia. Thank you again for this consideration.
Thank you very much for your testimony. Are there any questions for the lady? I see none. Okay, at this time, I will entertain, are there any questions from anybody on the committee? Okay, I will entertain. Do pass, do I have a second? Did you have a question?
I did, but I can ask him.
Go ahead and ask your question.
Thank you, Senator. I just had a quick question. The EMT language, that got added in this substitute that we have before us. Is that correct?
Yes, it did.
Okay, all right. Thank you for clarifying that.
Thank you. Any other questions? Now we will entertain a motion. And a second? We have a motion and a second. All those in favor say aye. Those? Aye. Okay. Any opposed? Your bill passes. You're on to a full committee tomorrow. Thank you. Now I have two more bills. Senator Harbin, if you would come forward. We are short on time, but I would ask you if you would please just, we're going to hear both of your bills, if you would give them both, and then we'll have that behind us. Thank you.
Thank you, Madam Chairman. I appreciate your courtesy in helping me do that, and I will deal with both bills. I'll introduce myself. This is the 7th year as a senator. I have 43 years of experience in the property casualty and life insurance business. I'm a certified insurance counselor, and I have a securities license as well. You know, I find that one of the things we see is how do we speak for those who can't speak for themselves? We have lobbyists that speak for industries, but not for individuals sometimes, and that's really what this bill is about. I would give you, this deals with life insurance, and there's 3 things that I would like to say, and then I have a presentation that's about 5 minutes, and then I'll close it up with that. You have 3 parts to any contract. It is the owner of the policy, you have the insured, and you have the beneficiary. And those are 3 people that are all involved in that process. And it's very interesting that under the current, most of the contract law, is the beneficiary is required to file a claim. But the beneficiary also has to know about that. And this bill has to do with 2 things. One is annual notification. The other is the ability for the insurance companies to search when there is a request for that. And I've got about a 5-minute video that I'm going to play, and then I will close out, is what they tell me. If I say play the video, it will play. So I'm hoping that will work.
When you take out
Those policies would be paid up. He may be dead, and you have to remember, life insurance is a life product. If it's for a long period of time, the agent may be dead even. And one of the things we have today is that the way the contracts are written, the beneficiary has to file the claim. And therefore, if we don't have an annual statement, which paid up policies, we talked to the insurance department, that if it's paid up and no premiums are coming, there also was no notice coming. At least if a notice, you would know the policy existed. The second would be for the company to check the national database that is provided by the National Association of Insurance Commissioners. So let's say your wife didn't know, she could go and put your information there, and the companies are supposed to check that and report back to the person that's doing the inquiry. So that would be the safety net. And currently it's voluntary rather than mandatory.
Thank you very much, Senator. We are not going to take a vote. We have some testimony, but we have overstayed our time.
I'm sorry.
I appreciate your bringing
Thank
us
you.
the bill, and thank you. We are adjourned.